Good afternoon. I know you're all thinking I'm here because this is a forum on affirmative action for Klingons. I don't speak it perfectly, but I'm pretty good at it. I decided after I heard Linda say that she threw out her prepared remarks on Sunday when she watched ABC that I would try to do it extemporaneously. Because I looked around, I've got a few notes here, and I looked around, I saw a few friends and acquaintances that reminded me of a few things. Let me back up. We're talking about affirmative action. There are certain premises that attend affirmative action. I think originally a lot of us thought it was a laudable goal. Casting a wide net, trying to take those who, but for the fact that they may be in a minority status, have been left out of the mainstream. But we've gotten to a point where affirmative action has essentially stolen a base. It's no longer about equal opportunity, it seems to be about equal results. Just think about the term diversity. Diversity really talks about results, the status quo. We have a diverse group of people, but how did they get there in the first place? Was it because of equal opportunity or because of desire for equal results? The first friend I saw was Stephen Thernstrom, who's written extensively with my colleague Abigail Thernstrom, his wife, about matters such as this. What if affirmative action is a gigantic fraud? In other words, the premise is it's supposed to take those who may have been left out of the mainstream, those who because of minority status have somehow been left behind, and take them and put them in a place where, you know, if they were in the majority, they probably succeed. Now, my night job is also on the U.S. Commission on Civil Rights. This is my second sentence on that commission. We have done a number of studies over the years related to the efficacy of affirmative action. If you don't care about the principle of equal opportunity, if you think it's more beneficial to engineer outcomes because you think that the result is one that will produce a harmonious society, well, let's just take a look at whether, let's test that proposition. It's testable. And Stephen Thernstrom has tested it. You take a look at, for example, Rick Sander of UCLA Law School. He's looked at bar results. He's analyzed this to determine whether or not those who are the beneficiaries of affirmative action actually succeed, and the results are just the opposite. Doesn't surprise anybody. You take somebody who went to an abysmal school in Collinwood, Cleveland, where I am from, dust him off after 4 years of a horrid education where he nonetheless got A's because of societal promotion, and say, go compete at Harvard with that guy from Phillips Exeter. Right. That's really going to happen. And what Sanders showed was those folks have a greater probability of failing. Not rocket science. Justice O'Connor said, well, 25 years. Maybe this will be all over. As Professor Thernstrom showed, probably not. Because what's happening is, for a while that is, the gap between minorities and non-minorities in essential disciplines, math, science, English, was narrowing for a period of time. It's now starting to expand. That is, 90% of black 12th graders have got the reading ability of the average white 8th grader. More than 90% of black 12th graders are below, in terms of test results, the average white 8th grader in science. The average black high school graduate has got the educational proficiency of an 8th grade white student. Those things are getting worse after nearly 40 years of affirmative action. And I mean affirmative action not in the originally conceived sense. I mean as is currently applied. Racial preferences, and that's what they are, the racial preferences. Let's do an exercise. Again, I'm doing this extemporaneously. It's a little bit of a high wire act, so bear with me. Remember Grutter and Gratz. Remember those cases? In Gratz, Michigan applied a 20-point total to an applicant's overall score for admission, okay? Simply on the basis of race. So if you take a similarly situated white applicant, That is, same SATs, same grade point average, same extracurriculars, work experience, and then you take his comparative, black comparative applicant. The black comparative will get 20 points added to his total. The Supreme Court said, no way, can't do that. Raw numerical weightings verboten. Grutter was the law school. In that case, what the Supreme Court said was race could be one of many factors in the admissions process, provided it wasn't a rigid point total. Race could be a plus factor, a feather on the scale of the admissions process. Okay? I want to ask you a question now. Given what you just heard, those are the essential holdings of those cases.